Kavanaugh?
On the possibility of remand for consideration of fair process, the Solicitor General says as part of that, the courts below could consider whether and to what extent Petitioner has preserved the issue. If he has, he'll bear the burden of showing that the sale was not conducted fairly. Do you agree with that?
We believe that's the first correct step, that at least one theory that can be challenged, but it's not the only theory that can be challenged on a remand.
What are the other theories?
Well, the other theory is inadequacy of price combined to this as well. So because you could have a sales auction that is entirely fair but still doesn't reach just compensation.
But do you agree you would have to show that you preserved the issue and that you would bear the burden of showing that the sale was not conducted fairly?
As someone who represents property owners, we always want to put the burden on the government whenever we can.
That's why I'm asking the question.
The court has not spoken to that answer yet, at least as I can see.
You don't necessarily agree. That's fine. I just wanted to clarify what you thought about that. And then secondly, Justice Sotomayor a few times has brought up Justice Scalia's opinion in BFP, and that does speak, as you know, very generally and broadly at the end about foreclosure redefines the market, and given that altered reality, the only legitimate evidence of the property's value at the time it is sold is the foreclosure sale price itself. And I just want to hear your succinct response to BFP and how you distinguish not only the holding, but the reasoning and rationale of BFP.
Of course, the first answer, of course, is always to point to footnote 3 in BFP and say in the Constitution,
which is a standard footnote, but that we use. But the question is the rationale and why it wouldn't apply more.
Because in the bankruptcy context, well, two answers to that question. One is in the bankruptcy context, Congress has the given separate authority to reallocate the burdens of debt between private debtor and creditor in those circumstances. This is an Article I, Section 8 question. We're not here on Article I, Section 8. We're here with the government with the takings style claims. So we think that easily distinguishes in that aspect. Importantly, BFP on the facts itself, and I won't get into tremendous detail, but the foreclosure occurred pre-bankruptcy. In California, at the time that foreclosure occurred, they had a challenge process that they could have challenged the unfairness of the foreclosure before it went into the bankruptcy process. And the property owner didn't opt to utilize that process, presumably thinking that the price got fair, and apparently their bankruptcy attorney thought differently once they got in there. So in addition to we're in different constitutional worlds, I think the facts that led up to the foreclosure and how the question was framed before this court got there in two totally different paths and are not congruous.
Thank you.
Justice Barrett?